Hello, everyone. This week we've been talking about waivers. Today we are going to talk about common waivers and what might cause you to be denied. A waiver is when a person who wants to come to the US as a visitor or to immigrate has done something that might cause them to be denied. The waiver gives them permission to apply for the visa or green card. I'm Raluca Hania. I am an attorney providing immigration business and estate planning legal services to my clients. And I'm here with my marketing and office manager, Nina Clear. And as usual, thank you so much for your likes, comments, and shares as they help more people to see my video. We did have a question on yesterday's video that I want to address. The question was this. Doamna Hanea, puteți să adresați în viitor informații despre redobândirea cetățeniei române. Basically, our visitor is asking if I will address how they can obtain their Romanian citizenship. I don't want to address that because my focus is on immigration to the United States, though I do have a law degree in Romania. In addition to the one in United States, I have not practiced law there, and I don't want to give you bad information or bad advice. But I do recommend you consult with the Romanian embassy or an attorney working in Romania. I put a link below your question.
Okay. So yesterday we talked a little bit about a provisional waiver.
Yes.
And it's all very confusing and detailed. So this is very broad information.
Yes.
But tell me a little bit more about the provisional waiver.
So first, I want to make it clear that this can be used only if someone is applying for a waiver for unlawful presence only. If you have been here without a status, the moment you leave the United States, you are not eligible to apply for a visa or legal status for 3 or 10 years. It depends on how long you've been here without a status. So in the past, these people had to leave the country before they could apply for a waiver. However, the provisional waiver allows them to stay in the United States while waiting for its approval.
Okay. And can anyone apply for a provisional waiver?
No. Only those who qualify as immediate relatives, such as a spouse, parents, or children of a U.S. citizen or lawful permanent residents.
And then after they file for a provisional waiver, we mentioned this yesterday, sometimes they still need to file another waiver, right?
Yes, if they have grounds for inadmissibility. Uh-oh, somebody's calling us. So if they have grounds for inadmissibility or inadmissibility factors, then the provisional waiver only gives them the right to stay in the United States while they are waiting for the answer for the provisional waiver. So this is most often used for parents or spouses whose family would experience a hardship if they had to leave the country. So the most common type of waiver that we have filed here in our law firm, it's usually the one is this one, the unlawful presence waiver. But I should clarify there is one form that I complete for most of my clients, and it's a form 601. But when you file it, you choose which category waiver for which you are filing. So this includes a number of things. So you might be not qualified to get to adjust your status because of health issues, criminal convictions, or having been in the U.S. past 180 days without legal status. So there are 17 items plus a category of other, which could also cover a number of things.
I'm back. Yay.
Yes.
Okay. So with the waivers that you have applied for clients, is there a most common one that you've done?
The most common one is actually this one, the unlawful presence waiver, but also I have dealt with individuals with 3 or 10-year bans or fraud issues.
Okay. And are those often approved?
I don't want to give you too much hope, but I have 100% success rate for the waivers I have filed. I have also applied for a waiver for some clients who had a prior waiver denied that was filed by another attorney, and then after we filed it, the waiver was approved.
Okay. So can you tell us what might keep someone from having their waiver approved?
One of the main reasons is failure to prove extreme hardship, which is a term of art, like everything in the law. And you need to read a lot of case law to know what extreme hardship means. So so that's the hardest to prove. And that is why I think it's very important to include a letter with all my applications that I submit. Plus, I always do my best to ensure that my clients submit sufficient documentation.
Okay. And is there anything else besides the extreme hardship that might cause a denial?
There may be aggravating factors such as fraud, as I mentioned before, willful misrepresentation, or multiple criminal convictions.
And again, those are all terms of art, basically from case law or statute. And
Yes.
since you practice that area of law, you're familiar with them and how you might be able to overcome them, or tell someone we won't be able to overcome that.
That's right.
Okay. So is there anything that helps you overcome fraud, those 3 that I just mentioned: fraud, willful misrepresentation, or multiple criminal convictions?
It depends, again, on each case. Again, it's immigration law is very case specific, and but if you can prove that you acted in good faith, that might help. Again, this is why I encourage everyone to hire an immigration attorney for any waivers, especially one who is a member of American Immigration Lawyer Association, as I am since 2011. Because being a part of that association keep us as attorney informed and up to date on case law and any statutory changes. Again, thank you so much for watching today. And tomorrow we'll run through a case study of a case I handled for one of my clients in the past. Thank you, and see you tomorrow. Bye-bye.